Hey everybody, how you doing? It's Ricky with another AZOI weekly video. Just wanted to connect with you today on something that we see very frequently in the owner-user transactions that myself and the team do. And what it is it's a document that's technically known as the Seller Property Disclosure Statement, but commonly known as the SPDS form. So a SPDS form is a form that really inherently is designed to go along with the Arizona Association of Realtors, the AAR, purchase and sale agreement. And it's a document that within that agreement, it actually is stipulated that in most instances, unless the language has been changed, that the seller shall provide this document to the buyer within 5 business days of opening escrow. And the SPDS form, again, the Seller Property Disclosure Statement, is a multi-page document that, again, is drafted by the Arizona Association of Realtors. And it allows a seller of physical real estate to disclose materially known items about the property that they're selling or relinquishing. Obviously, this is used substantially within residential transactions, but we use it commonly in owner-user commercial real estate transactions because it really allows the incoming buyer to understand everything about the property. And really, more importantly than anything else, it allows the seller of the property to disclose anything that they feel the incoming buyer needs to know. So it's a hedge against any risk at the end of the day for the seller to fill this form out to the best of their ability. Now, the form itself, which I've got in front of me, and we'll include a link to that form here in this video so that you can review it as well, is really broken up into a multitude of different sections. There's really, at the end of the day, 9 general sections for the SPDS statement. And in essence, the idea is that if you're unsure about something, disclose it. It could be something that happened 10 years ago, 15 years ago, whenever it did happen. It's important that you disclose that information, thereby letting the incoming buyer know what was relevant and material to the property and allowing them to make the best decision possible. Now, the form starts off with the ownership and property identification section. The ownership and property identification section is going to be everything that's materially known about the property pertaining to its address, city, state, municipality, what the assessor's parcel number is for the property, who the legal owners are, which, keep in mind, it could be an LLC. You might be inclined to put your names at that space, but it's how you actually hold title to the real estate. So could potentially be an LLC for the business, and whether or not the owner did at any point in time occupy the property. So there's check boxes here, there's blank boxes to fill, but ultimately is whether or not the owner is currently occupying the property or whether or not the owner has occupied the property in the past. This is kind of material to say that if you're maybe a doctor or an attorney, a CPA, that occupied your real estate for a period of time, and then you sold your practice to somebody else, or you vacated the space and leased it out, it allows you to kind of indicate what that relationship is. After that, section B, very simply, is the property type. Is it an office property? Is it an industrial property? Retail, hotel, multifamily, or other? There are certain categories of other specialty type uses. Then from there, what's servicing the property? What utilities does the property have? So section C speaks specifically to the utilities for the property. And with section C, and we see this a lot, so I bring this up because it's important to denote. In section C, on the left-hand side of the screen, you're gonna have checkboxes that are yes, no, then what the general category of utility is, and then provider sections. Obviously, yes or no, pretty self-explanatory. If you've got septic system or sewer, check yes or no for whichever is particularly applicable. And then for provider, for any utilities that you actually do have at the property, it's important to indicate who the provider is. A common issue that we run into is that, everyone assumes that the property has internet, but in Maricopa County, we have a lot of different providers for internet. You could have Quest, you could have AT&T, you could have Verizon, you could have Cox. So indicating who that provider is that you currently utilize is great because it allows the incoming owner to know automatically who it is that they can go to as well for those services. So it kind of gives them the opportunity to understand the whole picture for the property. The other thing is on certain things you'll see on here where it says domestic water, well water, fuel supply, garbage waste, fire protection. In certain parts of the valley, those services might not be provided by a city or municipality, but in the overwhelming majority of the valley, they are. So if you've got fire protection that's provided by the city of Scottsdale, put the city of Scottsdale. For fuel supply, if you've got natural gas or a propane line that's provided by Southwest Gas or something along those lines, put that in there. You might not necessarily be using it at that point in time, but maybe the association or the property has gas stubbed to the property and you're aware of it. It's easy to just put that information in there. It's up to the buyer as to whether or not they want to use that as well. Once we go out of the utility section for it, we start looking at section D, which is access and use. And this is where we start getting into the real important aspects of the SPUD statement. It's all important, but this is going to be one of the really important aspects of it as well, because access/use section D of the SPUDs is basically asking you as the seller, are you aware of any of the following affecting access or use of the property? These include things like encroachments, access easements, if somebody has to get through your property to get to their own property, utility easements. Does SRP or APS have power lines that are running over your property? Do you have a portion of your property that's not developable above a certain amount of feet because there's a high voltage utility line that's above it? Things like reciprocal easement access, shared use agreements, any kind of conditional use permit that might have been granted to you when you bought the site, or maybe someone before you has a CUP that's on the site. The other thing is, and again, understanding that a lot of the deals that you might interact with us on are owner user based. Is it part of an association? Are there CC&Rs, covenants, conditions, and restrictions? Are there going to be association agreements? Is there any kind of governing document that any inbound buyer would also be required to recognize and abide by? CC&Rs and bylaws are a perfect example of that. If you buy within an association, whether that's an office or a flex association, you're going to have to go through and do that. There are things within that document that at the end of the day are going to restrict or limit a potential other user's true utilization of that space dependent upon their business. So getting that information out in front is very, very important. So section D, pay particular attention to that. And then at the bottom of section D, and each immediately preceding section here, is going to be an additional 4 lines. Those 4 lines are provided for you as a seller to go through and fill out if any of the immediately preceding is yes. So if you selected that there's an encroachment, a access agreement, an association, and CC&Rs, then just simply put that. A lot of the time we'll tell owners, oh, our property is part of the X office condo development located at this particular property. That at least, again, tells the buyer, hey, this is what I know to be true about the property. Here's the information for you to do with what you want. From there, section E talks about compliance and legal matters, things that affect the property at a higher level than anything that might be recorded with Maricopa County. So this is more timely information. This is going to be any legal actions such as condemnation, pending or anticipated, that might affect the property. Things that a tenancy bankruptcy proceeding. If you're an owner of a property, you're selling it as an investment asset, and you're aware of any potential bankruptcy proceedings for the tenant, and you've been made materially aware of that, you need to disclose that. That might be something that any incoming buyer might want to know about it if they're going to be using it as an investment vehicle themselves. Other things that might go through and fall within the legal ramifications of zoning. Is the property currently being used outside of its currently permissible zoning? Do you see things that are an OSHA break? Do you see things that are utility services? Is there currently something going on with APS or SRP where there's additional elements of, hey, maybe they're increasing the KVA lines. Maybe there's additional things that we want to make the buyer aware of here that we're aware of. And again, this is a disclosure document. So anything that you have that might fall into this category, just let them know. So, and again, at the bottom of section E, you've got 4 more lines to really provide a brief description of what the known material is. From there, contractual obligations. This is exactly where we start to see stuff that has to do with tenants. So are there any contractual obligations that exist with you as the current user that might actually go through and continue to be enforced upon the buyer of the property? Things like telephonic services or internet services, those are cancelable at close of escrow. Those don't necessarily get enforced to the actual buyer of the property, but there may be benefits to going through and doing that. So again, work collaboratively with your broker and the buyer's broker and the buyer on the property to let them know, hey, I've got Cox, we ran fiber to the property. There's a benefit for using them directly. Do you want me to transfer that? And work collaboratively to make that happen. Other things are, at the end of the day, what we see on here is tenant leases or subleases, alarm security system agreements, property management agreements. Are there any kind of agreements that are going to survive that close of escrow that a buyer should be aware of. And obviously the most impactful one of all of this is if you're selling an investment property, is there a lease agreement that the incoming buyers are going to need to know about? That's a whole other thing. We go into estoppels and tenant agreements and analyzing those and lease types in other videos. But again, you're going through and letting the individual that's buying the property know what might be, beholden to the property itself. So that's going to be one of those things. Check these, make sure that it's there. And if it's not, just select no. It's okay to select no if you're not aware of anything. But if you are, select yes and provide a brief description of it. Then from there, section G is environmental factors. Environmental factors are pretty robust in the way that they ask things. That's by design. If you're aware of anything, simply select yes. If you're not aware of anything, select no. And again, with anything that's a yes, go through and let us know what that is. Let the buyer know what that is so that we can provide that information to them. And then important to know at the bottom of the environmental factors section, you're going to see describe any other known environmental factors that might affect the use or value of the property. And then also buyers are advised to obtain an independent environmental assessment of the property. I bring this one up because of the fact that if you're putting debt on the property or if the buyer is putting debt on the property, very commonly your lender will pass along via the buyer's broker or directly to the buyer or the seller, pardon me, an environmental questionnaire. It's a pretty basic form. It's basically the lender's environmental SPUD statement to get disclosure on what, again, this section G is talking about. So anything that you put on here, if you get that form as well, just make sure you're putting the same stuff on that. But that's what the environmental stuff is. Then really at the end of the day, section H, reports and studies. Do you have any of the following on the property? Very commonly, when we see real estate get developed, we'll see things like an ALTA study, an American Land Trust Association, or you'll see a phase 1 environmental research report, or phase 2. If you have any of those reports, select yes, go through, send it to your broker and have your broker pass it along. Because again, the idea is that any material information that you have in your possession, you're passing along. If you don't have it, which is understandable depending upon the length of time that you've owned the property and ultimately what you got from the seller who you got it from, then select no, and it's okay. Again, this is stuff that you have in your possession, stuff that's readily available and stuff that you can go through and materially produce for the buyer of the property. Then from there, you have material and physical defects and other miscellaneous factors. This includes things like structural, electrical engineering, or any other modifications made without necessary permits that you're aware of. Things like past or present roof leaks or roof problems, again, commonly within associations. We have had situations where the roof is the responsibility of the tenant, but majority of associations, they're going to maintain that themselves. So if you're aware of anything, disclose. Most of you that own in an association are already going through and reporting that to the association anyway, since it may or may not be their responsibility. And then things like historical districts, opportunity zones, things of that nature. If you're aware of it, select yes. If not, select no. Then really the other important thing here is understanding that every line must be filled out. Just because you select those elements that do affect the property does not fully complete the document in the eyes of Arizona Department of Real Estate, ADRE, AAR, and Title and Escrow Services. So if there's something there that doesn't affect the property, make sure you're selecting no. Make sure you're checking that box or putting an X through that box and allowing that to go through and say no on your behalf. Then once you're done with the document, you'll see a few different things. And this exists on lines 134 through 141. So there's the time of initial signature. So when you first fill out the document and when you first go through and fill out the SPUDS document itself, that's lines 137, 138, 139, and 140. That's going to ask for your signature, what your name is, what your title is within the organization, and what the name of the organization is. And then, kind of unique to the SPUDS statement, you also have line 141. Which is where you can update the document. Very commonly, myself and my team, when we take out a listing, we'll go through and send the SPUDS document to you ahead of time. We like to go through and build a due diligence doc that's really full of everything that we might need that any inbound buyer might want for the property. So if we send the SPUDS doc to you ahead of time, we're doing that for you to fill it out and then to go through and have it available to a buyer should we transact on it relatively quickly after taking it out to market, or just to have that document ready for when we open up escrow. In situations like that, what we'll do if a certain amount of time has passed from when you first filled out that document to where we are going under contract is we'll take line 141, we'll have you review the entire document, and then we'll just have you make sure that everything's up to date, nothing's changed, and we'll have you initial the document and date it. That's basically you going through and saying, hey, yep, it's been, call it 3 weeks. It's been 3 weeks, but I've reviewed everything, nothing's changed, here's my initials, here's the date, you're good to go. And then it's up to the buyer to review the document. And then at the very bottom of it, lines 142 through 152, sign, initial, and date themselves. Basically affirming that they've gotten the document, they've reviewed the document, and that they are in possession of that document for escrow and title services. The other aspect of this, which is kind of fun. So for the total number of pages that are on this document, both buyer and seller must initial the bottom of each page. So there's little initial boxes that exist on all 4 fill-outable pages. There's 5 pages in total. The first one's kind of instructions. Pages 1, 2, 3, and 4 are the ones that you fill out. Must initial the bottom of each page. Again, if those initials aren't there, the document's not considered valid until those initials are. That's kind of a SPUD statement in a nutshell. If you have any questions about it, if you need us to go through and provide any guidance on how to fill out certain things about the property, please feel free to ask, but keep in mind, as your brokers, we can't tell you specifically what's encumbering the property. We can't go through and tell you what easements might exist, what encroachments might exist. This is all information that you as the seller may or may not have available to you. And this document is your opportunity to say, this is what I've got, this is not what I have, I'll give you the stuff that I do, here's this document that affirms that. We, of course, can provide things like the APN number, we can provide things like the address and how the city of Phoenix or county of Maricopa looks at stuff. But in terms of those more material type sections, that's going to be something that really is just stuff that's in your possession. Again, my name is Ricky. I appreciate your time. If you have any questions, please feel free to give me a call, shoot me an email. We'd be happy to be a resource for you and your real estate. I work at SVN on the AZOI team here in Phoenix, Arizona. I do appreciate your time. Hope you have a great day.